Welcome everyone to our Hunt and Hunt lunchtime webinar on trademarks. I'm just going to wait a few minutes while we have more participants joining our presentation today. It just takes a couple of minutes to allow everyone to come in. But if you're already in, welcome. Thank you for coming today on this lovely Wednesday midday, actually, 12 o'clock afternoon. So we'll get started in about 1 minute. You should be seeing on your screen our presentation, which says trademarks protection. If you've got any issues, then just pop a query in the Q&A and we'll see if we can help sort you out with that. But you should be seeing both me and our presentation. Okay, we will get started. So again, welcome everyone to our Hunt and Hunt lunchtime webinar on trademarks. We're looking at the basics of trademarks today, but also discussing why it is important to register a trademark. So for those of you who don't know me, I'm Sarah Capello and I'm a partner in our commercial litigation and dispute practice in Sydney. We're doing something a little bit different today. I'm not presenting this webinar at all. I'm just here really as another face and to help operate the Zoom. And this is because we're very lucky to have Georgette Georges in our commercial team here in Sydney. Georgette was recognised as a rising star in IP in 2021 and she's joined our team and she's a wonderful addition. So her star continues to rise further and further, and today she's going to be sharing with us her extensive knowledge on trademarks. So thank you so much, Georgette, for taking the time to do this.
Thanks for the very, very kind words and nice introduction. I'm very excited to be here and presenting my first webinar on trademarks.
Wonderful. So what will we be talking about today? So firstly, please note that this session is being recorded and we'll also be sending these slides to you along with a link to the recording after today, so probably in the next few days. We hope to have some time to answer some questions at the end. However, if not, we'll be sending our contact details out and we welcome you to get in touch with us so we can help you through what is often a pretty complicated process, which you'll discover after hearing from Georgette. So Georgette has also prepared some frequently asked questions, which might cover some of the areas of interest for you today. But as I said, if not, just get in touch with us and we're happy to help you through it. So as I said earlier, Georgette is going to go through the basics such as what is and isn't a trademark, and then she'll explore more in depth the benefits of registration and how to protect an important asset. So passing over to you, Georgette, tell us, what is a trademark?
All right, so what is a trademark? In simple terms, a trademark is your business identifier. It's a sign that distinguishes the products and services that you provide from those that are provided by your competitors. So we've got the definition of a trademark as set out in the Trademarks Act. I'm not going to read it, but I'll give you just a brief rundown of what it is. Simply put, a trademark is a sign that makes the goods and services that you provide in trade stand out from the rest of the crowd. So basically, it's what connects you or your business to the goods and services you provide. It can be a range of things such as a name, a word, a logo, a phrase, or a jingle, just to name a few. So we've got a couple recognizable trademarks here on the screen. I'm sure most of you that are watching would be familiar with all these trademarks. I'm definitely certain that I probably don't need to tell any of you who owns a trademark. There's a glass and a half in everyone.
Oh, hang on, Cadbury, is that right?
That's right. So basically what you can see from here is that there are many different types of signs which are capable of distinguishing goods and services that are dealt with in the course of trade. These examples show that a trademark doesn't necessarily have to be your brand name. However, it can be anything that you adapt which allows consumers to identify the connection between the mark and the product or service you're offering. For example, there's a glass and a half in everyone. So a very important point to make about trademarks is that not all use of a particular sign will be considered used as a trademark. So whether there has been use as a trademark will be determined objectively by examination of the use in the context in which it appears. So use as a trademark means that a mark needs to be used in the course of trade. This means using the mark as a badge of origin. For example, stamping your logo on the products you sell or on your product packaging. Use that is solely descriptive is unlikely to be used as a badge of origin, and therefore the sign is unlikely to perform that branding function and will not constitute use as a trademark. So an example of descriptive use would be using a trademark to refer to a product or service in a blog or vlog, as people like to use these days, so a video blog. Basically, the blogger could write or say, "Today I went to the shops and I ate a Big Mac." Although Big Mac is a registered trademark in Australia, the mark is being used to describe what was eaten for lunch, and therefore is descriptive, and such use is unlikely to be considered use as a trademark.
Is another example, Georgette, this slide right here, how we've used these logos.
Yeah, exactly. That's exactly right. So with trademarks, there are many misconceptions. The following, the ones that we've got up on the screen are the most common misconceptions that we hear when clients come to us with trademark issues. So first and foremost, the most common misbelief that people have is that a business name registration is the same as a trademark registration. This is not the case. A business name registration is required by law if you wish to trade under a name that is different to your company name or your own name. However, a business name registration does not grant the holder any exclusive rights to use the name. It is merely a trading name. This is an important fact that you need to remember. Although there is no legal requirement to register a trademark, registration of a trademark provides these clear exclusive rights to use, license, and sell that mark, which could be your trading name. Another misconception that we see all the time is, my trademark is registered in Australia, so I have global trademark protections. A trademark registered with IP Australia offers protection only in Australia, Australia-wide, but only in Australia. There is no such thing as a global trademark registration. To register a trademark in an overseas jurisdiction, you would need to file a trademark application in each relevant jurisdiction, and that application would need to be assessed and determined by that country's IP office before the mark could proceed to the next stages of the application process. This is something that we'll touch on a little later down the track as well. And last of all, my trademark is registered in Australia, so I have trademark protection for everything. This is definitely not the case unless you're registered in all 44 classes of goods and services which you can be registered under. So when you file a trademark application, you need to choose what classes you seek registration for. Now, when I talk about classes, I'm talking about the categories of goods and services that are available for you to register your mark. IP Australia offers 44 categories of goods and services in which you can register your mark. However, you can only rely on protection offered by the Trademarks Act in the classes of goods or services for which your mark is registered. For example, if you are a retailer and retail services is all you provide, you will seek to register your mark in Class 35 only. This is a class which retail services falls within. If your application is successful, IP Australia will raise an issue with any future applications for marks that are similar to yours and also seek registration in Class 35. Being registered in Class 35, however, does not mean that you have a monopoly over all classes of goods and services, and therefore it is unlikely that IP Australia will raise issue with applications for the same or similar marks in completely different classes and totally unrelated goods or services. On this point, you can't also apply to register a mark in any class which you do not provide or intend to provide such goods or services. There are significant consequences to doing this, and this is also something that we'll touch on a little later down the track.
So I know, Georgette, you're going to be touching upon this later, but with respect to the global trademarks, I know a lot of clients feel overwhelmed with the notion of having to register in every single country, but it's not the case that you have to find your own lawyer in every country. Is that correct? Can you tell just very briefly how the process would work in terms of just they can come to you and then you have connections?
So we have relationships with lawyers all across the country, a part of an organisation called Interlaw, and so we've got direct ties to lawyers in every country. And yeah, so if you want to lodge an application in, say, the US, for example, you can come to us. We'll happily facilitate the whole process, and we'll have our person on the ground in the US running that application for you.
So the only person you need to really know is Georgette.
That's right. We'll take care of the rest. Okay, so who is a trademark owner? Now, this is a concept which is not as simple as it sounds. The owner of a registered trademark can be anyone with a legal personality. So it could be an individual, a company, an incorporated or unincorporated body, even a political body such as a government department. The applicant in respect of the trademark application is considered the owner of the trademark. That being said, it is crucial that the applicant is the true owner of the mark. And this is something that needs to be considered prior to lodging the application. It is very important because ownership of a registered trademark or application can be challenged at the application stage or even when registered. So, like we said, it's not always an easy answer. There are many circumstances in which the validity of the applicant's ownership can be contested. These circumstances can arise in situations where the mark has been used prior to lodgement of a trademark application by another party, or the entity named on the register as the applicant is incorrect. For example, this could be an application was filed by an individual. However, the individual has never actually used the mark in the course of trade, but rather it has always been used by a company owned and run by that same individual. So in these situations, generally, where a dispute arises in relation to determination of who is the owner of a trademark, the owner will be considered to be the first person or entity that has used a mark in Australia. This being said, it is extremely difficult to correct ownership issues in relation to trademark applications or registered trademarks. It is also, this is why it's so important to get the applicant right from the outset. This concept was discussed recently, well, not that recently, but in 2017 in the case of FAM Global and Insight Clinical Imaging. So basically what happened in this case was Insight Clinical Imaging had been trading since 2008 using its trademark. It did not apply to register its mark until October 2012. In December 2011, Mr. Pham, the sole director of FAM Global, applied to register a mark which was similar to the mark being used by Insight Clinical Imaging, and he applied to register that mark in his own name, not in the name of his company. The application was successful, and opposition was brought against the application by Insight Clinical Imaging, and the application for opposition was successful on the basis that the FAM Global mark was substantially identical to the Insight Clinical mark, which was first used by Insight Clinical Imaging, and also that Mr. Pham was not the owner of the mark, as he never had an intention to use the mark personally in trade or commerce, nor had he licensed use of that mark to FAM Global. A very important component of this case is that after receiving notice of the opposition, Mr. Pham decided to assign the trademark application to the company FAM Global. And this concept was discussed further in the decision, and basically it was held that ownership by the applicant must be satisfied at the time the application was made and filed. It cannot be satisfied after. So where an application has been filed in the name of a person that is not the owner, not the owner or the wrong owner, an assignment to the correct owner will not cure any subsequent deficiency arising from that application. So in simple terms, it was found that assignment of a trademark application or registration is not a quick fix in circumstances where applications have been filed by applicants that are not the correct owners of the mark. This really stresses the importance of ensuring that the applicant in respect of a trademark application is the correct entity. So registered and unregistered trademarks. A trademark can be either registered or unregistered. However, there are significant differences in the way in which the rights attaching to each of them can be enforced. So there are many benefits to registering your trademark. These include having an exclusive right to use, license, and sell the mark. The fact that a registered trademark can be dealt with as a standalone asset and can be assigned, sold, or otherwise dealt with independent of any business sale. Although it is an intangible asset, a registered trademark can be dealt with like a house or a car, And similarly to vehicle registration of a mark evidences clear ownership rights to that mark. With a registered trademark, you're able to enforce your intellectual property rights under the Trademarks Act and protect your mark from infringement by other traders. And lastly, your mark will be published on the Australian Trademarks Register. This is very significant as it provides a clear indication of ownership of the mark and the goods and services protected under that mark. This is a very effective tool in deterring others from using the same or similar marks in relation to those goods and services for which you have registered your mark. In contrast, an unregistered trade, in relation to unregistered trademarks, if your mark is unregistered, you cannot rely on the same benefits as a registered trademark under the Trademarks Act. It is not considered a type of property under Australian law, and therefore it can't be dealt with like other tangible property. Rather, it attaches to the goodwill of a business and will be transferred with the goodwill of a business in a business sale, even if there is no intention to do so. This concept was determined in a recent decision which was upheld by the High Court in 2020 in the case of Kraft Foods and Bega Cheese. You can read more about this case in the next slide. But basically what happened was it was determined that even if there is no intention, if a business is sold, any goodwill includes unregistered trademarks, and therefore an unregistered trademark will be assigned with the goodwill of that property, of that company, sorry, of that business, I should say. Also with respect to infringement of unregistered trademarks, the owner of the mark would need to consider other avenues to pursue infringement claims, as it can't rely on the Trademarks Act for this. So in these circumstances, you might need to look at the Australian consumer law and file a claim for misleading and deceptive conduct, or also look at common law and the tort of passing off. But in both scenarios, in both circumstances, these require substantial submissions to be made, and overall more work and more costs are involved. Lastly, in terms of unregistered trademarks, the absence of a trademark registration means that there is no clear indication to the public as to who owns this particular mark and what goods or service it is used in relation to. So here's a little bit more about the Kraft and Bega case. I'll let you have a read of this in your own time, but basically the outcome was unregistered trademarks are not considered under Australian law as its own species of property, and therefore will attach to the goodwill of a business, and therefore in the circumstances it will be inherited by the purchaser of the business.
So Georgia, I know you're going to be touching upon this later, but by doing so, by adopting this path as it did in the Kraft and Bega case, you're not really realising the full potential of the value of the trademark. Is that what your assessment of this case? You kind of really diminish how you can maximise the value of that asset.
Well, yeah, that's entirely right, because the result of this was that, you know, Kraft thought that they could sell the business and then continue to use the same trade dress, which was the unregistered trademark in question. So the look of the whole peanut butter packaging. So they thought, hey, we'll sell the business off, but then we'll still we'll start a new peanut butter business, and this peanut butter business will use that same trade dress. And you know, Bega bought the business and they started selling their version of peanut butter using the same trade dress. And then it got to a situation where they were both using this same very similar trade dress minus their respective logos. And Kraft thought, hey, no, we didn't give this to you, but really it was held by the court that no, yeah, with the transfer of the goodwill of the business, the unregistered trademark fell under that. If the trade dress was registered as a trademark, that could have been specifically excluded from the business sale, and therefore Kraft could continue to use that, and Bega would have had no rights to use that trade dress.
It always blows my mind that these, you know, substantial companies overlook these. this is something, yeah, it's quite interesting to me that it's something that's not really considered, which is quite a distinguishing packaging. But anyway, that's
yeah, definitely. And this case, but in particular, was one of the was one of the first to kind of touch on this point that, hey, no, these unregistered trademarks attach to the goodwill of the business, whether you like it or not. So it's a really important case because it's now set this new standard, and it's brought this new concept that we need to think about when it comes to registering trademarks and the benefits of that. So moving on to this next slide, this table just provides a side-by-side comparison of some of the rights that attach to registered and unregistered trademark. We've touched on most of these, but basically it highlights the importance of trademark registrations. There's one extra point which I'd like to make, which is that having a registered trademark allows you to use that R symbol. Some of you might be familiar with this or have seen this. So the R symbol indicates to the public that your mark is registered and that you have clear exclusive rights, intellectual property rights in that mark. If your mark is not registered, you have no rights to use this R symbol in Australia, and fines will apply for unauthorized use of this. You might see people using the TM symbol. This just symbolizes that the mark is a trademark for that company or that brand, but it is not registered. And it does not appear on the IP Australia register in Australia. But clearly from this table, it's in our opinion that there are significant benefits that flow from trademark registration, which are definitely worth taking the time to consider.
So Georgette, you and I spoke earlier about how another common misconception is that the use of the TM, people often think that gives you the same protections as a registered trademark, but that's not correct. So
no, that's
going
right.
back to the benefits of registration, it's really important to do that. Otherwise, you're potentially not realising that value.
Yeah, and basically you're cutting out the hard work for people in terms of they see your mark, they see that they're like, yep, this is registered. I'm not going to play around with this.
Yeah.
Yeah, so it is definitely a big value adder in that space.
So you've convinced us how. You convinced us to do it. So tell us how.
So an application for registration of a trademark must be filed with IP Australia. It can be done via the IP Australia online services function. And obviously we can help you with that and all aspects to do with that. We've demonstrated how important it is to make sure that the ownership details are correct before you apply to register a mark. But there are many other things that also need to be considered. And given what we've spoken about so far, it is very clear that applications aren't as simple as people think that they are. They're quite complex, and if prepared incorrectly, they can carry significant consequences for your trademarks and your business. So once a trademark application is filed with IP Australia, it'll be determined by an IP examiner. So basically the examiner at IP Australia will either accept your mark for advertisement in opposition, or alternatively, they'll issue an adverse report setting out any issues with the marks that need to be remedied before the application can proceed to the next stage, which is advertisement for opposition. So it's not only essential to ensure that the correct entity is your applicant in respect of the application, but it's also important to ensure that your trademark application has reasonable prospects of success. And to do that, you really need to consider the matters listed in this slide and deal with them before you lodge the application. So specifically, first off, you should identify exactly what your trademark is. So this is very important, as the benefits of trademark registration attach only to use of the trademark in the form which it has been registered. So you can register your trademark, say, for example, McDonald's. That word can be registered and you will have protection for use of that word like that. However, when you start to mix that into other things and phrases and maybe add it into a different kind of logo and change the whole appearance of it, this is where things start to get tricky, and this trademark protection won't extend to those different types of uses. So it's very important to identify exactly what your trademark is as a first step. You also need to carefully consider the classes in which you require registration and prepare class descriptions that are accurate and compliant with the class requirements. So as a general rule, you should not apply to register your mark in any class which you do not currently provide goods or services or intend to provide them in the near future. And lastly, you should always, and I can't stress this enough, conduct searches of the Australian Trademarks Register to determine whether there are any prior registered trademarks or applications which might stand as barriers to registration of your trademark, or whether it's possible that the use of your mark is infringing the rights attached to a prior registered trademark or application. So I can't stress this point enough, especially if you are a startup business. You know, if you are a startup business, you need to be wary of what's around you, because you don't want to be spending money on marketing and branding and doing all these things just to get knocked back from IP Australia because there's another person out there using the same or similar marks as you. In situations where you've been trading for a long time and you've built up substantial evidence of use of the mark, it may be possible to overcome certain objections raised by the examiner in relation to similarities. But again, this is a case-by-case basis thing, and that's why it's always important to do your searches first.
And Georgette, the searches are kind of a little bit more sophisticated than just, Googling at 10 o'clock on watching Netflix. They require a little bit more in-depth analysis, is that right?
Yeah, definitely. So, I mean, the way I do searches is, first of all, I take your marks, I do a search of the Australian Trademarks Register to see what's registered in any class, first of all, to get an idea of what's out there. And then I shrink that into then the specific classes that we are looking at, or any other associated class. So an associated class is a class which is not the same class, but may be considered similar by the examiner. So yeah, I do it like that. And then I also conduct all the other background searches like your company searches, your Google searches, just to get a general gist of what's out there, how long these people have been trading for, how long they've been using the mark, and so forth.
And this kind of highlights too that often people think trademarks is essentially form filling, but it is so much more than that, as you're describing.
It is definitely not just form filling, that's for sure. It is a very, very detailed process, and it goes through very thorough examination by IP Australia. So it's very important to get all the details correct. There are some instances, like I said, where we can overcome little minor issues that an examiner may raise, but definitely when it comes to applicants, this stuff needs to be considered and considered at the get-go to make sure that bigger issues don't stem from this. And we'll talk more about this in a second. Okay, so intention. This is a very important concept in terms of a trademark application. So the intention that you have when filing the trademark application is very relevant. So per the Trademarks Act, in order to file a trademark application, you need to be the owner of the mark. We've talked about this already. And you must have an intention to use the mark in Australia or assign the mark to a company not yet established, or you must have authorized or intended to authorize use of the mark to another party. So applications filed for illegitimate reasons with the wrong intentions can be subject to removal from the register. So an example of this could be a situation where the applicant did not file the application in good faith. For example, it was made for the sole purpose of standing in the way of a rightful owner from lodging an application. So in Australia, if your trademark application is successful, it will be registered for a period of 10 years. And this 10-year period starts on the date which your application was filed. After 10 years, you are able to renew your mark for a further period of 10 years, but this will be at a fee, of course. So in order to maintain a valid trademark registration as well, you must, the trademark, which was the subject of the registration, must be continuously used or continuously used in good faith in relation to the goods or service for which it is registered for a period of 3 years in Australia by the registered owner. If it can be proved that the registered trademark owner has not used this trademark in this way, the registration may be subject to withdrawal from the register on the basis of non-use.
I'm sorry just to quickly interrupt you, Georgette. We're getting a few questions come through. Just to give you a heads up, we'll be answering questions at the end, but please do keep sending them through as they come up, and we'll do our very best to answer them. And if not, we'll be in touch with you after. But so thank you for submitting them. I'm not ignoring you.
We'll get to them. As we mentioned earlier, we kind of touched on overseas operations. If you're trading overseas, it is important to consider ways in which you can protect your trademark in these overseas jurisdictions. As I mentioned earlier, given the trademark registered with IP Australia offers protection Australia-wide only, if you want trademark protection in other overseas countries, you need to file an application in that country. International applications can be lodged in 2 ways. So either directly with the IP office, as we spoke about earlier, we can liaise with our colleagues in various jurisdictions and help facilitate that process. But the alternative to that is using the Madrid system. So the Madrid system allows for lodgement of one trademark application, but that application is then designated in multiple countries. So this can be a more cost-effective approach in situations where you wish to apply for registration of the same mark in the same classes with the same class descriptions in a range of countries, as it can be done through one application. But there is a catch to this. The designated countries, so the countries which you want to register your mark, need to be signatory to the Madrid Protocol, which not all countries are. And the other catch is that once filed, each IP office will still need to determine the application, and it will be examined by that specific IP office. So before you file an international trademark, you should definitely identify the countries in which you require the protection. This will help us identify whether the applications can be done using the Madrid system, or whether we need to engage in our colleagues of that local jurisdiction to file that directly with the IP office there. We should definitely conduct trademark searches to ascertain whether there may be any issues with prior registered marks in that jurisdiction. So just because you have a mark that is registered here and you're able to use freely here, it doesn't mean that there isn't a trademark which is the same or similar that is registered and being used in another country. So it is definitely worthwhile, before lodging any trademark applications in those jurisdictions, to have a look at what's going on over there, purely to save money on applications if there is clear indication that you will not be successful, but also make sure that you, even if there isn't a registered trademark, that you're not going to be sued for using something similar or the same in that jurisdiction. So what can't be registered as a trademark? So as a general rule, not all trademarks can be registered with IP Australia. Broadly speaking, some trademarks that can't be registered include marks that are descriptive, for example, warm for heaters, marks that contain geographical indicators such as Bass Strait for seafood, common surnames such as common Aussie surnames, I should say, like Smith and Brown, or other common signs or phrases, abbreviations such as MRI for medical services, or extra small for clothing, so XS for clothing. There are, however, certain circumstances where IP Australia might allow registration of some of these types of marks if the owner is successful in providing substantial evidence that the mark is capable of distinguishing the goods and services it provides from the goods and services of others, irrespective of the above. This is determined by IP Australia on a case-by-case basis. However, we do not recommend applying to register such marks without having substantial evidence of use, which provides that the mark is distinctive to your business. And by substantial evidence, I'm talking about 3 or more years of solid concurrent use that can really show that by you using this mark, you've created a reputation in this mark, and therefore the products and services that you offer are distinguished from those that are distinguished from those that are provided by other traders who offer similar services or goods.
Georgette, you and I spoke about this earlier. Even though some of the names couldn't be trademarked, doesn't mean you're prevented from using them. Like, for example, Sarah's strawberry drink. Sarah's very common names. We wouldn't be able to trademark that, but I could still have a drink like that. It just wouldn't have the same protections as a registered mark would.
Of course, because Sarah's strawberry drink would be descriptive in nature, and Sarah is a common name, I would say. But that doesn't mean that over time you can't you can't build up a reputation in that. If your use becomes distinctive over a certain period of time, then you could probably look at ways in which you could work towards gaining some sort of trademark protection under the Trademarks Act. But you would also potentially have other avenues that you could rely on, such as misleading and deceptive conduct under the Australian Consumer Law, or passing off.
But first I'll start my searches, is that right?
That always conduct your searches, always. Because it means that another person won't be using that if it's descriptive, and they could have been using that for 5 years before you've been using it, and they might come at you with a cease and desist letter saying, hey, you're by you using this mark, you're misleading consumers to believing that we're linked party, or that you are us, or whatnot.
Yeah, which is what we do. You touched upon a good point, which is what we do for many clients, sending out those cease and desist letters so you can protect your registration.
Exactly. So the next thing I wanted to touch on, which I think is very important, is the need to properly document trademark arrangements. So as mentioned earlier, trademark use requirements can be satisfied by either the applicant or an authorized user. So someone who's been authorized by the applicant to use that mark. It is not uncommon that a trademark applicant is not the actual user of the mark. This is common in corporate groups who sometimes opt to hold IP in a separate IP holding company, or in other commercial situations such as franchisor and franchisee scenarios. It was also the situation in the FAM case, where the individual was the applicant, however, the user of the mark was actually the company FAM Global. According to the Trademarks Act, to be an authorised user, the entity that uses the trademark must use the trademark under the control of the owner, and must deal with or provide goods or services in relation to which a trademark is used in the course of trade. So the validity of registrations, specifically in relation to satisfaction of use requirements, can be disputed if proper authorization or licensing arrangements aren't put in place. So whether a user is not related to the trademark owner, care really needs to be taken that actual control over the licensee's use is exercised and is recorded so that evidence can be produced if the owner needs to defend a non-use action. Where companies are related in a corporate group, it is still important to have this documentation in place. As in the absence of this documentation, the court will need to rely on evidence to determine that the entities have a unity for purpose, so that being a common purpose and an end goal. For example, their common purpose is to maximize sales and enhance the value of the brand. Again, this would require submission of evidence, which if you had this all documented in a proper agreement, you could just hand this up and say, here you go, here's my license agreement, and this is what we've agreed on, and therefore use of the mark can be established, and it can be established if that was in fact authorized. So all in all, our view is having the correct documentation in place is very helpful in defending these types of claims for removal of a trademark application or registration for non-use. And as such, it's definitely a matter to be considered on or before an application is made. Okay, so the value of trademark registrations. So registered trademarks are what I like to call as value adders. They add value in many ways. They're valuable marketing tools as they help clearly distinguish your business from the businesses of your competitors. They protect identifiable features of your brand. A registered trademark also represents the goodwill of your business. Goodwill relates to the reputation of your business and is an asset which has a dollar value placed on it at the time the business is sold. A registered trademark also allows you to earn income from licensing the use of the mark to another party for a fee. And also they can be sold independently from a business, also at a fee. So pretty much adding value all around in terms of your business and your reputation, as well as some real dollar value as well.
So we're getting into the question portion, and Georgette has kindly prepared some frequently asked questions. But since we have a few questions that have come through the chat, we might address those questions live through this webinar. But Georgette will prepare some answers to these frequently asked questions, and then we will send them along with a copy of this recording and the presentation slides. So now's a great time to add any more questions if you like, there's two that have a common theme, and so we'll deal with those together. So the questions were about using trademarks as a whole, or whether you can kind of split parts off of the registered trademark to use separately, and also whether a business name and a logo needs to be, the two elements need to be used together, or whether it covers protections for both separately. So for example, the McDonald's example where you have the name and also the golden arches, does it give protections just to the image, or to the name and the image, or the image by itself? So how would you deal with that, Georgette?
So in situations, for example, like McDonald's, I would always recommend, if there is a name that you use in logos, in conjunction with other things, if your name is special to you, I would always recommend registering the logo, the name first and foremost. Because if the name is distinctive, then you want to have protection for that distinctive name. And there's two reasons why I say this. One, because then you can rely on it a little bit more in terms of you can add it to descriptive things. So you could say McDonald's burger, and no one, although you might not have a registration for McDonald's burger, the fact is McDonald's is the prominent element of that mark, and you've got a trademark registration for that. So chances of someone else being able to register McDonald's burger is low. Purely one, because it's also descriptive, but because the prominent element of McDonald's burger is McDonald's, which you have registered, it will most likely stand in the way of someone trying to register that mark for a burger. So that's why I always say, take your name first and deal with that as its own asset, because it allows you to kind of play with it in certain ways. Or then if you register it as a word mark, you can stylize it in certain different ways. You make it pink, you can make it blue, you can change the font, but the actual word itself is protected. When you're looking at logos, logos can be a little bit different. I would also, it depends on how similar your logo is to your word mark. McDonald's also has that M, which it uses on its own a lot. In that situation, I would also apply to register the M on its own as how it looks, purely because it's not always used with the word McDonald's. So if the word McDonald was registered as a trademark, that's all well and good. And if it was used, and sometimes it is in those golden arches, then it might deter other people from registering McDonald's with those golden arches. But when you use those golden arches on their own, there's definitely no protection offered there unless it's registered as a trademark. So I think you've got to break it down and see how they kind of intertwined and go from there.
Yeah, I guess the answer is, as usually the answer is for lawyers, it really depends upon your circumstances, but you need to go and get the right advice from someone like Georgette.
Well, that's right. But also, I mean, when trademark examiners look at your application, they'll look at what are distinctive elements to that. So if there's a logo, it'll take a look at how similar that it'll compare other prior registered marks to your logo, and it'll kind of say, okay, what are the similarities? What are the differences? And you really want the differences to outweigh the similarities in that situation. And having, if your name is part of that logo, having that registered as a trademark will help your case in saying, hey, it's distinctive. I've got this registered as a trademark. So already this kind of identifies me and my business.
So what you often do, Georgette, correct me if I'm wrong, is you develop a strategy once the client comes to you and says the kind of protections they're after. And so the strategy will include whether they should be done together or separately. It depends. Yeah,
definitely. So usually someone comes to us for a trademark application, or they kind of got no idea where to start. I will always take a look at take a thorough look at your business. So I'll jump online, jump on your social media, ask you for materials, and kind of see what marks you're using, what marks have become distinguishable to your business, what consumers are likely to associate with your business only. And then we go, then we take a look at how we can protect each one of these business identifiers, essentially, and what's the priority, because I know sometimes it can be a bit costly when you've got 5 or 6 masks that you use. We have to look at, what's the priority. A lot of the time it's the name, if that name is special or different, that usually is the first and foremost. Or it could be the name of a specific product which has become, your bestseller, and which you hold a lot of value in. And again, that's beneficial in circumstances where you have a product which is a bestseller. You trademark the name of that product, and then later on down the track, if you go to sell your business and sell this company, you've got a lot of value in your product. And also in the fact that you have this trademark registration, and nobody else can have this registration in the same classes. So
yeah. So there's 2 more questions. One question I'm happy to deal with as the last question, which talks about what happens if a company ignores a cease and desist letter. So it's about so it's really enforcement of that protection. But before we get there, Georgette, there's one more question for you to answer, and this is something we spoke about earlier today, actually, and that's, can you discuss a little about the issue of a trust owning a mark? It is not the true beneficial owner, but held on trust for the trustee. Since trust cannot own the trademark, do we explain in detail the trademark application? So I guess they're saying, how can you, in terms of the corporate structure, if you want to have a trust or trustee really is the one who's going to be owning it, how can that work? How can you make that work?
So a trust can't hold the IP in itself, but the trustee for that trust can. And again, that trustee can be a company, or if it's an individual, that would then need to be the applicant, but it can be as held on trust for, and you can say the name of the trust.
So I guess the question is, if they're not using it, if the trust or the trustee rather doesn't have any intention to use the mark, how can then it be held in terms of that structure? And I guess this is what we spoke about today in terms of those larger corporations who do have that IP holding company. This is where you need to have those properly documented arrangements in place. So it comes back to making sure that you've got that structure.
Yeah, and that could be, depending on what the situation is, that could be in the trust documents. But there has to be some sort of a trail that says we're holding this on trust, and this entity is using it. And again, that comes back to the proper documentation, which if in the circumstances, that's what's in the situation where you want to apply for a trademark and you want it to be held on trust, then we would have a look at, all the trust documents and go from there in terms of figuring out the best way to document that. But the important thing is to document the relationship and document the fact that it is held on trust.
Yeah, okay, wonderful. And so this kind of touches upon, and I was going to mention this later, about why IP sits within the commercial space. So Georgette's in our commercial and corporate team rather, and this is why it is an element of that proper structuring when it comes to your business protections, to make sure that you're getting it done, and that every element of it is talking to one another. So your structure and how that holds the property is quite important as well.
Yeah, definitely.
So the last question is, if you send out a cease and desist letter and the company ignores it, what can you do next? So this really comes, what essentially happens in practice is it goes from Georgette's department to my department, where it comes into the litigation space. And the answer to that question is really depending upon how that trademark has been properly registered, and we need to first look to see whether they're infringing any of your trademark rights. If not, there's certainly other avenues you can explore, which means if you don't have a properly registered trademark, it doesn't mean that you don't have remedies. You should definitely explore those remedies, but it just becomes slightly harder because it's not as apparent as what it would be if you've got a registered trademark and there's a breach in that respect. But there are claims, that Georgette's touched upon that. There's misleading, deceptive conduct claims, there's passing off claims, and they're things that we do commonly at Hunt and Hunt. But the very first step is you go to Georgette with the information, the documentation, which you'll have properly done because you've been to this webinar and heard the advice about that. Go to Georgette and you say, this is my trademark, this is what the other company or the other business is doing, and what do I do? And it's very simple to send a cease and desist letter, and often that is incredibly effective. Yeah. And if not, then it goes to that next stage of litigation where we're looking at things more specifically.
Yeah, I mean, and that's not always to say it will be litigated. There are times where settlements can be reached between parties. And again, it doesn't mean that it has to be litigated, but if you can't, you can maybe eventually come to some sort of an amicable solution between both parties, and figure out how the marks can be used and who can use what. And that does happen too sometimes. So that's.
Now, I said that was the last question, but there's one more question that's come through that I'm actually quite interested to know what the answer is, because I don't know the answer to this. And should a seal of a notary be registered as a trademark? So can I tell you what I think, Georgette, and then you can answer? I would think no, because it's not used in the course of trade.
This is a good question. There are certain marks which can't be registered. I mean, I don't think it should be registered. That's not to say you can't apply to register it. I don't see why you wouldn't need to register it. I mean, is there a specific reason why you would want your seal registered as a trademark? Whether or not it's used in the course of trade, it depends on the circumstances. Again, it really depends on is there a bigger reason as to why you're going to be you want this seal registered as a trademark? Do you put it on your website and say, hey, Notary Public, this is my seal, and kind of use it as a logo? This concept would need to be explored.
It's an interesting one, because I actually don't know that, because it's not necessarily the seal that is I guess being sold, but it's the services of the Notary Public. And we might need to take that offline and speak to the person asking that question, just because it's quite an interesting question. I don't know how we can't answer that in the 5 minutes we have, but we will be able to answer it in the long run. All right, so just wrapping things up. So thank you so much, Georgette, for the time, and thank you everyone for those really interesting questions that you've posed. I hope you take away from this, the message is that, it might, as I said earlier, it might look like form filling, but it is so much more than that, and it's really important to get this right. Now, we really approach this webinar from a protection kind of aspect in terms of what you need to do to protect, but as we touched upon just at the end, there's also an enforcement aspect. So what you can do to kind of enforce those rights once you are properly protected, and that's kind of a whole other webinar, which we might have an idea for. I can rope Georgette in for that. Yeah, but the message to take away is, get in touch with Georgette if you have any questions about this stuff, because there is sometimes a solution we can work through. We work out strategies. It's a really valuable asset to your business. You make sure not only to kind of protect, but also to avoid any disputes you might have against you. So it's not necessarily the case that you might needing to be enforced. So it might be that you need to defend a claim against you. And when you're operating a business, you just don't need that stress and that time to really kind of go through and be distracted from it. Exactly. So, and in comparison to that, the cost of actually getting these trademarks registered and getting the advice from Georgette is really very reasonable, particularly compared to the cost of having to defend a dispute. So when you compare it, you're talking tenfold in terms of the difference in costs. So it's a lot more cost effective to get it done right and be proactive, which is the case for many, many things, than having to look at the other end of things. But again, thank you. We've already gone through the questions now. We've got one last thing to note before I let you all get back to your Wednesday. And next year, we're roping Georgette in. She hasn't agreed just yet, so maybe the public pressure will go there. But Georgette's also got quite extensive knowledge on privacy as well. So we'll be looking at doing a webinar in 2023, but we'll give all of my wonderful team a break for the rest of the year. They're exhausted. They work very hard. But if you want more info and you haven't already, signed up to our newsletter or get in touch with us and we'll happily pass on any of the information. But thank you so much. Here are our contact details. Thank you for being here today, and we really appreciate all the support, and a big thank you to Georgette, our rising star.
Thank you, and thank you everyone for your time. I hope you enjoyed the webinar. Feel free to reach out if you have any further questions. All right.